attorney out of this courtroom.
I'm denying that because what you have said here shows
You
that
are
you
in
have
violation.
no understanding.
You are in violation of my rights.
Laws.
The oath that you took, you're in violation of. I am demanding my Sixth Amendment right to go pro se, and I would like this attorney out of this courtroom.
I understand your request, and I respect that you think that you understand this process. Clearly,
You do
by
not
your
respect
remarks,
me, Your Honor.
you do not understand, and I am duty-bound to make sure that you understand before I allow you to go
I
pro se.
perfectly understand. We established that the last time I was here.
Well, clearly your remarks today suggest otherwise.
According
Can
to you,
uh,
not according to the law. We're
Mr.
talking about the law, we're talking about rights. We're not talking about what you think. We're talking about what is
Future,
right,
you can
fully
go ahead
mine.
And
That's what we're talking about here today, and that's what you're supposed to be talking about here today.
Mr. Luke, you may proceed.
Thank you. Judge, I had read the information in file 17 CF 1013. The information is comprised of 2 counts of fraud against a financial institution. I'm going to read those elements and I'll make the elections that are required that I think that fit the proof that the state has. Number 1, the defendant, Gregory Rael, obtained money owned by or under the custody or control of a financial institution. Financial institution means a bank or a credit union chartered under the laws of this state, another state or territory, or under the laws of the United States. Element number 2, the defendant, Gregory Rael, obtained by means of false pretenses or by use of any fraudulent scheme money or a monetary instrument. A person obtains money by means of false pretenses or by use of any fraudulent scheme when, with knowledge that it is false, and they act with intent to obtain money. And finally, it says if you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty.
In that, those elements are the elements that apply to both counts 1 and 2 in that information?
Yes, those would be elements that would fit for counts 1 and 2. The defendant's charged as a party to the crime, but I don't know that that's particularly relevant. He was a principal actor in this with the state's evidence will show that he was a principal actor.
Thank you. And then if you can read to Mr. Rael the information in the other file and then indicate the elements as the state intends to prove them.
All right.
I object.
I, John
object to these
Woodruff,
readings, Your Honor.
Assistant District Attorney for Brown
I
County,
understand.
Wisconsin.
No, you do not understand.
Hereby inform the court that count 1, the above named defendant on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, did intentionally cause bodily harm to Dan Magnan, a law enforcement officer, without his consent, and at the time of the act, the defendant knew or should have known that Dan Magnan was a law enforcement officer, and the act was in response to any action taken by a law enforcement officer in an official capacity, contrary to section 940.203, parent 2, Wisconsin statutes, a class H felony. And upon conviction, the defendant may be fined not more than $10,000 or imprisoned not more than 6 years or both. Count 2, the above named defendant on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, did knowingly resist an officer while such officer was doing an act in an official capacity and with lawful authority, to wit, arresting him, contrary to section 946.41, parent 1, Wisconsin statutes, a class A misdemeanor, and upon conviction, the defendant may be fined not more than $10,000 or imprisoned not more than 9 months or both. Count 3, the above named defendant, Gregory Rael, on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 Wisconsin statutes did intentionally fail to comply with the terms of his bond, contrary to Section 946.49, Parent 1, Parent B, Wisconsin statutes, a Class H felony, and upon conviction may be fined not more than $10,000 or imprisoned not more than 6 years or both. That's it.
Thank you. And if you can identify the elements for each of those offenses, please.
Yes. Well, I'm reading directly from 1240C, which is the pattern jury instruction for battery to a law enforcement officer. Element number 1, that the state must prove the defendant caused bodily harm to, in this case, Dan Magnan. Cause means that the defendant's conduct was a substantial factor in producing bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Element number 2, Dan Magnan was a law enforcement officer.
The record should reflect, has stood quietly and appropriately during that time. He is accompanied by officers here today. Mr. Rael, have you heard the presentation that the state has made with respect to the information and to those elements?
I do not consent to the reading of those charges. The state's attorney, I would love the state's attorney to prove to me that he has legal authorization to even charge me with any crime. I've heard his gibberish, as you put it, and I would like to myself add, for the record, I demand that all oral, verbal, written, signed contracts, law, etc., that I have entered into with this court, signed, spoken, be revoked, stricken from all records. I do not wish to enter any further any contracts, laws, statutes, rules, regulations, or codes orally, verbally, and or written with or without my knowledge during these proceedings.